Before Robin gets to say a word,
Right.
let me say first that she began her day at 6 o'clock this morning, then drove up here. It was a 3-hour drive this evening from Boston. And
Massachusetts drivers cannot drive.
And then she has to drive back tonight. So,
So support public radio.
yes, exactly. Which leads me into, have you given your contribution this week to New Hampshire Public Radio?
888-805-6477.
Or you can just write a check when you get home.
First of all, what an honor to speak with you again in front of an audience. We've done this before, and it's always a pleasure. And I just want to say a personal word. We Are Here and Now has grown. It's world domination, but we always, always thank the listeners to NHPR, some of the first believers in Here and Now, so thank you very much for that. And you've hired away half our staff. I don't know if Virginia Prescott is here, but a good move. So, Nina Totenberg, a new session starting on Monday. Before we talk about some of the cases coming up, can anything match June of last year and all the cases of the last session?
Probably not.
Yeah.
There are few times when there's that kind of thunderous opinion as same-sex marriage, much less Obamacare 2 and some other important decisions. So, probably you could count on two hands the numbers of opinions since the, let's say, 1965 or something like that are of that importance, and that everybody understands from the very beginning are of that importance. So probably not, but there are one or two cases, really one case this term, that could end up being that important, though I doubt it.
Well, let's start with that.
So the court has not yet accepted this case for review, but it's sitting there waiting in the wings, and I think it probably will. And it's a test of the Texas abortion statute, which has been copied by other states. So it's significant in the sense that it's not just Texas, it's other states as well. And it restricts abortions to abortion clinics have to follow the same structural rules as a hospital, basically. And that's extremely costly and would automatically cut the number of abortion clinics in the state by well over a half.
And in Texas in particular, it also is impossible in some areas because it's so rural.
Yes, and it's a huge state.
Yeah.
So women would have to travel, in some cases, up to 300 miles round trip to get an abortion. The lower court upheld it, saying only some 900,000 women might possibly face that trip. But the point is that the court has said there can't be an undue burden on the right to have an abortion. So if that's not an undue burden, what is? And then the other thing is that those who perform abortions have to have privileges at a hospital within 30 miles, and given the politics of abortion politics these days, that is often impossible. They import people to be doctors at these clinics. So if those kinds of restrictions, and there are more, are upheld, I think it's fair to say that abortion would be very difficult to obtain in states where there is a clear majority of people willing to support the pro-life position. And while abortions would be relatively easy to obtain in some other states, they would not be in probably half the country or more.
So what do you think is going to happen? We were talking before coming out about how the justices might go. You were speaking of Anthony
Kennedy.
Yeah, Anthony Kennedy, although you refer to him as Tony. We'll get to that in a bit. As being somebody you're watching, where do you think it's going to go?
It's hard to know. Justice Kennedy has supported the right to an abortion, but has rarely almost ever been willing to strike down restrictions on the right to abortion. So he's extremely tolerant of those kinds of restrictions. And so at some point, if the so-called undue burden test could become pretty meaningless, because if all you have to have is a rational basis for enacting these kinds of restrictions, and that is the lowest threshold, then Roe versus Wade is, for all practical purposes, eliminated. You may not say we're reversing Roe versus Wade today, but that's, in point of fact, what's happening. Now, this doesn't mean you can't have the right to an abortion in many, many states. It's just that you can also make it illegal for all practical purposes.
We were talking about this. I mean, in the reporting that we've been doing, this is something that the anti-abortion, pro-life side is very transparent about. They aren't even concerned as much about Roe v. Wade as they are at picking at these different aspects of it so that it makes it, in fact...
I think they understand a political reality, that the Supreme Court is loath to say the magic words, "We today reverse Roe versus Wade." But there are 4 and maybe 5 members of the court who are willing to pick away at it till it's not much of a right anymore.
Yeah. All right, so we'll keep an eye on that case. I was interested in the death penalty cases. How do they loom for you?
Well, there are a whole bunch of them this year, but none of them addresses the question that Justice Breyer raised at the end of last term. He said he thought it was time to revisit the question of whether the death penalty is cruel and unusual punishment. And none of them...
This was in the Glasser case considering lethal injections.
That was in the case involving lethal injections. And he raised a bunch of issues not really related to lethal injections, but he pointed to studies that show not just that there are racial disparities in the way it's administered, but serious geographical disparities, and not by whole states. Not that New Hampshire doesn't have the death penalty, which I don't even know if it does or not. Okay, New Hampshire does have the death penalty, but Massachusetts doesn't.
Yeah.
But rather that counties...
Well, we can't drive, so...
But rather that counties within a given state have such different rates of imposing the death penalty, and that usually is less a reflection of the citizens who serve on the jury than it is of the prosecutors who bring the case and seek the death penalty. And so when you have those sort of disparities, the question he raised is that constitutional? And then he raised a bunch of other questions about whether you can actually say that it's retribution that it's a deterrent when it's so rarely used, and most importantly, the question of the number of people who have been on death row who are subsequently proved innocent through DNA testing. And I think there's probably a lot of work to be done yet to prove some of these points to a better certainty. He, after all, suggested only that the time had come for the court to reconsider the question, and I don't expect the court is going to reconsider the question anytime soon, but I expect that those who oppose the death penalty will seek to have some empirical data that doesn't exist today on the question.
So meantime, I mean, he raised all of those points, and it got a lot of people excited, thinking that something was going to happen. But none of those issues that he raised are in the cases that will be before them starting on Monday. So tell us one or two. The Florida one I like.
I think actually, the death penalty cases are, for the most part, on the periphery of the issue. So I'm going to tell you about one or two cases that are not involving the death penalty. There's a very important labor case for, 40 years or so. You do the math. It was 1977 that the Supreme Court ruled that if a majority of workers in a public sector decide to be represented by a union, other public employees within that group of people do not have to join the union, and they certainly don't have to pay for. They don't have to pay for the political activities of the union, but they do have to pay their fair share of the bargaining costs because they benefit from the contract that is subsequently negotiated. And a great many states have laws that say when there's a union bargaining agreement, it applies to everyone, that you can't negotiate for half the people there and not for the other half of the people. So since they benefit from the bargain that's struck, from the contract that's struck, they have to pay their fair share of the bargaining costs and the grievance procedure costs that they also benefit from, and that cost the unions quite a bit of money to administer. And in the last few years, there has been a very clear voice on the court, led by Justice Alito, saying, maybe it's time to reverse this. And there are clearly 4 justices who think it is time to reverse this, and the 5th justice, who in the past has supported the idea of fair share payments, is Justice Scalia. And so if he does what it looks like he's going to do, which is side with his fellow conservatives on this question and say this is a violation of the non-members' First Amendment rights because anything that a union does, even negotiate a contract, costs money and costs the state money, and therefore is a political subject of debate, and therefore the non-members shouldn't have to pay for it. That will, if that is the case and the court reverses the case called Abood from 1977, it will seriously hobble public employee unions and potentially, ultimately, other unions, although public employee unions today are more than a third of the public employees in the country are unionized, and only 7% of the non-public sector is unionized. So for unions, this is pretty much a last stand legal argument, and they will be seriously hobbled if they lose this one, and there's quite a serious reason to think they will lose this one. So there's that case, and there's a case that tests what is the meaning of one person, one vote. Oddly enough, the Supreme Court has never said what that means. In the context of the Constitution and Congress, it's pretty clear, most people say, it's pretty clear it means the total population of people in the district, because the Constitution does not speak in terms of voters, it speaks in terms of people representing the people. But that's not true necessarily in the states. So does it mean the total population of the state, including people who are legal permanent residents, but from other countries, they're not non-citizens, illegal immigrants who live in the state, children, people who've been convicted of a crime and therefore have lost the right to vote? Does it include all of those people? At the moment, it does in virtually every state in the country. The question is, does the Constitution require that for state legislative races and districts as well as Congress? And that's what the court has to decide. Or does it has to be just those, or is it can conceivably be just those eligible to vote, or even just those registered to vote? And that's the question before the court. Obviously, if the court says, well, it can be just those eligible to vote, it will seriously reallocate a lot of legislative districts and will probably mean a significant boost for the Republican Party. I think it's doubtful the court ultimately will do that because it's so difficult to get the data. I mean, you ask any state in the country if they know how many convicted felons they have in the state. They don't know how many people are registered to vote. You know, these lists are old, they're not properly purged. It's very difficult to know anything more than what is the total population of the state, which the census does do that work. And beyond that, they don't tell you. all the little subdivisions. So I think from a practical point of view, the court is going to look at it and say, as my late great-grandmother used to say, "Oy vey, mir." I mean, how are we going to do this? So, but, it's a very interesting question, and it has very serious potential consequences.
I have to, since you said that, my former co-host, Bruce Gellerman, the fantastic reporter now, Bruce Gellerman, had one of the greatest billboard lines ever. Remember when the Mir satellite broke through and came and landed? His opening line was, I'm Robin Young, I'm Bruce Gellerman. Oy vey, it's Mir. Sorry, that was his. It was such a great line. So last year there were those cases that are, the ones you've just spoken of are wonderful and broad and will have big impacts on a lot of things. But is there a case that's just kind of odd? Still, obviously, they all have impacts, but last year, the man who had threatening rap lyrics about his wife on Facebook, or the Confederate license plate in Texas. Is there something like that is, captures
well, there is
imagination?
the Pennsylvania judge who upheld the death penalty for a defendant who had been sentenced to death when this particular judge was the district attorney who authorized seeking the death penalty. I think that's sort of a no-brainer myself, but
There's that. We're going to be having questions from you all afterwards, so if there are questions about cases coming up or the session coming up, we'd love to have them. But I want to get your thoughts, Nina, on how the Constitution, this is a Constitution event, constitutionally speaking, how the Constitution has been spoken of in the presidential race. Start with, you have Ted Cruz, who says that he will amend it to end birthright citizenship. Now, Donald Trump is against birthright citizenship, the idea of someone is born here, even to parents who are not citizens, they have a birthright. But he says, it would take way too long to change it, so let's just say that it doesn't mean people who were born to people who are children of undocumented immigrants. Let's just say that it doesn't mean them. As you're listening to the Constitution invoked this way, your thoughts?
Robin, that's not fair. I did a piece that's in the can, as they say, although now it's no longer in the can, it's in the computer, for Monday Morning, about the current term, which begins talking about the way that the various candidates talked about not just the Supreme Court, but John Roberts, the Chief Justice, in particular. And, John Roberts has a very conservative record. He has, he was a dissenter in the same-sex marriage cases. He has voted against any racial preferences, against affirmative action. He wrote the opinion striking down the key provision of the Voting Rights Act. He has consistently voted to strike down regulations governing campaign finance campaign spending, and all of which has opened the floodgates to enormous amounts of cash in our election systems, not just at the federal level, but at the state level as well. And there's only one subject on which he has cast a vote that conservatives don't like, and that's Obamacare. And so that's his cardinal sin. But the way that everybody was talking about him during that second debate, you would have thought he was a liberal like William O. Douglas. I mean, it was sort of bizarre for anybody who knows anything about the court. This man is a very conservative justice. And even Jeb Bush said that he would fight for his nominees and that fighting was sort of the essential part of this, and that what was wrong with John Roberts essentially was that he was confirmable by the Senate. I mean, it's just sort of, I went back and I looked at the transcript and I sort of scratched my head. You want to be really not just not just fair, but also appropriate when you talk about something like that, and you have a hard time. So I wrote a line that I changed. So I used a cut, I think, of Ted Cruz saying, if Barack Obama had not been elected, then, if John Roberts were not Chief Justice, something like this, we would have gotten rid of Obamacare, and same-sex marriage would not be legal across the country. And my original line was, never mind that Chief Justice Roberts wrote the lead dissent in the same-sex marriage case. But I decided that that was too snippy, so I changed it to something like, of course, John Roberts wrote the dissent.
Well, but look at the other, much was made of Republicans when those cases came out, saying, well, it's just the Supreme Court. Why is the Supreme Court getting to judge, things like health care? And, it's
because somebody has to is the answer.
There's a disconnect there.
Somebody has to. That's the way the Constitution is written.
Right. But Hillary Clinton has come out and said that she wants to explore the...
she said she would have a litmus test.
Well, but she also said that she wants to push for an amendment to, in effect, overturn the 2010 Citizens United decision. But isn't that the same? Isn't that someone saying the court was wrong?
Of course, there's nothing, lots of times people say the court was wrong, and if you're lucky, it's not a constitutional ruling, it's a statutory ruling, and you can get Congress to go back and change the law. And that happens on both the liberal and the conservative side, and not that infrequently, or at least used to happen not that infrequently, but these days Congress doesn't do much of anything, so, But if the decision is based on the Constitution, then the only way to change it is by a constitutional amendment. And there's nothing wrong with trying to have a constitutional amendment, except that all those of you folks who clapped when they said, that she favored a constitutional amendment, I defy you to sit down and try to write something about the First Amendment that would change it in a way that would not open a door to something you would really hate a lot.
But remind us, so what would the language have to be?
Well, so let's give you an example. If you wrote a constitutional amendment that said only, money is not speech for purposes of the First Amendment. Okay, that sounds pretty good. Now, let's say you're in the middle of, let's pick an unpopular war like the Vietnam War, and you want to run an ad in the newspaper. You want to buy, or you want to run an ad on TV, let's say, or on the radio that opposes the war. And the local radio or TV station won't sell you the time. And you've met all the other qualifications, and they're discriminating against you based only on the fact that you oppose the war, and you want to spend money on their network or on their station to oppose the war. Well, you're in a bit of a pickle.
You're not protected. You're not protected. What about Dr. Ben Carson and his feeling that if a religion doesn't abide by the Constitution, which is, I'm paraphrasing greatly what he said about the Muslim faith, that somebody should not be able to be president?
I really think that it's inappropriate for me to actually speak about these candidates. I have always been a registered independent, at least until I finally changed my registration to Washington, D.C., which you have to be a Democratic voter, otherwise you don't get to vote about anything. It's such an overwhelmingly Democratic city that if you want to actually have any voice in who's the mayor or who your city council person is, you've got to vote in the Democratic primary. But I have always been a registered independent, and when I lived in Massachusetts, that meant I could vote and did vote in the Republican primary often, and voted for Republicans often in the general election. And so as well as Democrats often. And so I really feel very uncomfortable telling anybody other than in the privacy of my home at a dinner party or with my friends at the movies or something, what my view of Ben Carson or anybody else is, unless they say something that is factually inaccurate, like Ted Cruz about John Roberts. Because my opinion's no better than anybody else's opinion. You can make your own judgment about that.
It's just us. And all this. Talk about the dinner parties at your home. You've had the justices over for dinner?
Not as a group.
Not as a group. Because would they not?
Never.
Is that one of those where you could not seat so-and-so next to so-and-so?
No, they're not that big. We're talking about 6 or 8 people for dinner. We're not talking about
okay.
some grand, thing with... We make dinner. People serve themselves and sit down and have dinner.
Are there off-the-record conversations?
Oh, they're all off the record. I mean, you don't have people for dinner and have it be an on-the-record conversation, God knows. But I would never ask a justice about a case that was in front of them or anything like that. And that's sort of the quid pro quo is, and a lot of these people that sit on the court, I have known for a very long time, and way before they were on the court. They're not going to be my friends now that they are on the court? That's ridiculous.
So, tell us one thing, or maybe there's more, that would absolutely floor us about a justice, that you can't know unless you've known them.
Well, some things you know if you've read a lot, for example, about Justice Ginsburg, that ideally her day would start at noon, and she works till 3 or 4 in the morning. So, of course, she's a little sleepy sometimes, because when she gets to court, she may have had 3 hours sleep. She's got, she works every night until 3 or 4 in the morning. Her hot pen, as she puts it, heats up in the evening. And so that's when she does most of her work. And
so that's why she fell asleep.
Will leave a dinner party and go home to go to work. And so famously, when I asked her at this interview that I did with her and Justice Scalia, which was a wonderful interview, if I do say so myself, because they both came to play, and they went at each other hammer and tongue, and with very good humor, and it was really a very entertaining. But it was just a week or 2 after she had fallen asleep at the State of the Union, and like this, and she'd been caught on camera, so I told her I was going to ask her about it, because it seemed to me that you couldn't not ask about it as a reporter. So I asked her about it, and she said, well, first she said, it's easy for the members of Congress to stay awake because they're jumping up and down all the time. And then she said, but we sit there sober as judges. and then she said, except that, of course, I wasn't entirely sober because we had dinner at the court beforehand, and I told myself, don't drink any wine. But Tony Kennedy brought this wonderful California wine, and I just had to have a glass or 2. And she said, and I really miss Justice Souter, because when he used to sit next to me at the State of the Union and I would start to nod off, he would pinch me. Justice Souter, I know you're out there somewhere. And she said, Steve Breyer leans into me, but he doesn't pinch. That's not good enough. I need somebody to pinch me.
Does Clarence Thomas, does he speak, is he loquacious at all? I mean, when he's outside of the courtroom.
Well, I don't see a great deal of him because he doesn't, and he lives quite far outside Washington, and he doesn't do a lot of the things that one might see somebody in, he doesn't go to sort of big a big legal reception at the court, you're not likely to see him there. I see him at the Supreme Court musical concerts, that he does come to those, but then he leaves, so you don't actually, talk to him there. And, I don't see him at other musical events or theater events in Washington. So he did ask questions early on in his tenure on the court, and I think it's 7, maybe 8 years that he hasn't asked a question. And I think that this is now, for him, a decision he made. And he's right about the fact that often counsel does not get to really make their argument because they're getting so pummeled with questions. And he said, he, as somebody who argued before courts as an appellate advocate when he worked in the state AG's office, that he liked being able to make his argument and not be interrupted every 2 seconds. Well, that's not the way it is in the Supreme Court. It's typical that justices will ask, over the course of an hour-long argument, 70 or more questions. And it's a very hot bench these days, and that's just the way it is.
Hot bench,
Mm-hmm.
meaning?
It wasn't a hot bench when I first started covering the court. It was much quieter. But I think that this is their only chance to sort of not only hear what the advocates have to say, but get a sense of what the concerns are of other members of the court. And other than, this is not like Congress, where they have committee hearings and there's a lot of personal lobbying. That doesn't go on a lot. I mean, sometimes members of the court, 2 or 3 of them, will meet to discuss a particular opinion they're working on, maybe jointly, or that they're trying to work out some sort of a compromise they can all live with. But for the most part, it's a pretty solitary job. And they work in 9 separate legal chambers, and they write individually and circulate the material to each other, and then get back a lot of feedback, and then there's a back and forth that's largely in writing. So that the only time they sit down together is at the conference, the weekly conference after the oral arguments, when they speak in order of seniority, and nobody gets to speak a second time until everybody's spoken. So that's sort of limiting. So the oral argument is a very, I think, important to some members of the court. But and Scalia says that the worst experience he ever had as an advocate was standing up when he didn't get asked a lot of questions. So different strokes for different folks, and obviously Thomas has made a decision that he doesn't want to ask questions anymore.
When are we going to get to hear what goes on in the court? Do you think there...
You can hear right now.
No, but I mean, in our lifetime, there will be cameras in the court. There's no cameras in the court.
No. And I don't expect to see that in my lifetime either. I don't expect to see it in your lifetime either. You know that your own Justice Souter famously said at some congressional hearing, having had the experience of having a Supreme Court that is televised here, as I understand it, that when they rolled in the cameras, they'd be into the Supreme Court, they'd be rolling them in over his dead body. And, you know, I think there is an argument to be made for that point of view. Among others, the one that you don't hear, but I think is a very serious matter, is that the Supreme Court is a pretty cloistered institution. And if you want to see it totally cloistered, you put them on TV and they will need round-the-clock protection. They will not be in the supermarket feeling the melons by themselves. They will be universally recognized. And you know, they get a lot of protection now when they go to a public event, something at the Kennedy Center or something like that. You'll see the little guys with things in their ears around. But they drive themselves. They live a regular life. They take their children to school. They, you know, they have the normal. I once was getting my nails done, and I walked out and I see the Chief Justice of the United States down the hall. Nobody has recognized him. He's looking, there's a little ballet school for children down the hall, and he's watching his children in ballet school through a little window. And it's such a wonderful insight into him. I mean, this is some years ago. They're young teenagers now, but they were, kids. And apparently his son insisted that he do everything that his sister was doing. So he wanted to go to this dance school, and there was a separate little class for boys. And so Roberts is watching the 5 or 6 little boys doing stuff with a teacher. And he's standing there, and he's watching them, and he turns to me, and he says, "I don't understand it. He does everything she tells him and nothing I tell him."
Well, I thought you were going to say that you looked up and the Chief Justice was getting his nails done.
No.
Next to you.
So I just had gone down the hall to say hi, and he's looking, and I said, "What do you," and he tells me this whole thing. So then he turns to me and he says, "I don't get it."
Well, you're privileged to have that.
So.
Well, you're privileged to have that seat. You have that seat on that world as it unfolds. And I know audience members want to ask more questions, so we want to remind you that there are ushers in the aisles with question cards. Unfortunately, we can't see.
Listen, the two of us couldn't see if we could see.
It's true. That's so true.
And out of great vanity, I don't have either my reading or my distance glasses on, which means I can't see beyond probably
Watch
there.
out. The edge of the stage. Go right over. But we do have some questions. Are you ready?
Yeah, you're going to ask me about the violin?
Oh, absolutely. That's coming.
Since we've been asked to say something.
That's sort of the big moment at the end. But let's ask some questions about the court. Is it difficult for you to remain unbiased when interviewing someone with whom you disagree?
No. I have to say that the best, first of all, I really do try to keep a little bit of a distance and not be hugely invested in the outcome of most cases. And you can do that most of the time, because when you read the briefs, you actually do see that there are good arguments on both sides. It's very rare that a case comes up where I can't at least see the argument on the other side. Even if I wouldn't like it to come out that way, I understand what the argument is, and it's a perfectly legitimate legal argument.
Well, it's the Supreme Court, so it's already made it through these lower courts.
Right.
Yeah.
So, and the second thing is, if you want to have a good piece, you better damn well get good interviews on both sides. And the last thing you want is a weak sister on one side, because then the piece is no good. Then I end up having to say the punchy, good stuff. I don't want to have to do that. I want both the advocates on each side to be as good as they can be. And if I can't get somebody to do that, I am constantly fishing for somebody better to do it. So it's no difficulty. You can see what the questions are to each side. You just, this is rocket science. You ask them some hard questions, and they better have good answers. And if they're any good, they do have good answers. And if they're not that good, they have mushy answers, and that's the worst thing.
I hate that
you can have.
Well, stay with that for a second. This is NPR, and as you're well aware, after Juan Williams left because it was felt that he had expressed his opinions on the television show he was a part of, that a lot of the articles after that were asking about you, because you also have had a long history appearing on Washington Roundtable, those wonderful TV shows. And people felt that on occasion you had expressed your personal opinion, that Michelle Obama made people feel warm and fuzzy, that I can't even remember what some of the
Well, I did
was.
express my personal opinion sometimes, but at no time that I can think of, this is the great irony of these things, did I express my personal opinion about anything I covered. So you might have been able to figure it out on occasion when I wasn't particularly artful, but my object always was not to do that. And the things that I felt perfectly free to express my opinion about were the things I probably knew the least about. So if you ask me what I thought about, what should we do in Libya, I probably had an opinion. I read up on it and called a few experts, but, you could destroy me in a minute probably, because this is not my field of expertise. So this is the media world we live in, that it is good for us to be on television, and as well as radio. It gets you recognized, and so people return your phone calls. And you want to have your phone calls returned. And that's just a very good thing. Now, NPR is a very powerful journalistic institution, but it helps to have the television exposure in addition. And I did Inside Washington for 21 years, and it definitely helped me as a reporter to have people know that I was going to be on television every Friday, Saturday, and Sunday, because they repeated it, and that they would be, that I would have some information that they otherwise that they wouldn't have heard if they weren't listening to the radio. So that was always very good for me. And I think, I felt very strongly that what Juan said might have been something I wouldn't have said, but I didn't think it was grounds for firing him if you didn't like his work. And people at NPR did not like his work. They thought he didn't work well enough for them. It just wasn't. It was not working as. It was just not working as an employer-employee relationship, and that didn't have anything to do with his personal viewpoints. Then they should have not renewed his contract, and that's the end of it.
And that's your opinion.
Mm-hmm.
Yeah, I'm willing to express. Actually, I just want to talk. This just popped into head, which is always dangerous. But you're my hero in many ways. But one in which there's an ongoing conversation about NPR, about what we can and cannot say, and it is to the point where what we love about NPR is that it is marvelously cautious and concerned about listeners and does not want to offend.
We're sometimes too concerned about listeners.
And sometimes too. And we have this constant, what can we say? And mine, the one that put me over the edge, I was doing a healthcare piece, and I hope I don't offend anyone here. But it had to do with women's health in what the blogger Jenny Lawson calls the lady garden. But so it had to do, it was vaginal health care. It was a story about vaginal health care. And I was not allowed to say the word vagina. And we also had a piece on our Renee Graham, who's just this wonderful pop culture critic. We have this occasional segment where we ask people involved in music, what is your sense of American music? And she wanted to showcase Nina Simone, Mississippi Goddamn. We had to bleep Mississippi Goddamn. So you don't get the impact of this. I mean,
yes,
songs
and
you sing.
I've been rather outspoken about this.
You were wonderful. We get these system-wide emails, and you wrote one back.
I can't write them anymore because I don't have access anymore to the
They cut you out?
system-wide email. Nobody does. They took it away. They didn't like that the Washington Post then wrote about it, so
I didn't even know that.
Yeah, so I don't get when I hit reply all, it says you are not an authorized.
Well, I love this when this came because we got another missive about what we can't say, and you wrote out and said there is no legal question here, and how are we going to talk about, for instance, public officials who have done something?
Well, I felt in this instance that we were bleeping out too much, and apparently there had been some legal opinion from somebody in our legal department saying that we could be fined for not just bleeping, but bleeping and leaving in the first initial.
Yeah, we can't even leave in the
B, sh, whatever, so that people would understand what you're talking about, because sometimes you can bleep out stuff so much you have no idea what's being talked about. So, when there was that thing at the University of Oklahoma, I think, where these guys were on the bus
Oh, right.
saying
The
racist
fraternity.
remarks. We bleeped it out so totally, I had no idea what they were saying. So I wrote this, and I actually looked at every fine that had ever been levied by the FCC.
And that is one of the concerns.
It's online. You can look at it. And there had never been an instance of anybody being fined for putting an initial, letting the consonant be in there. And so that's what I wrote, and I popped off further about that.
And now you're
So,
blocked.
but I have to say that I had this wonderful experience recently where there's a book out called Sisters-in-Law, which is about Ruth Ginsburg and Sandra Day O'Connor. It's a very interesting and good book. And there was a wonderful anecdote in it, and I wanted to use it, and I couldn't figure out how because I thought it would get bleeped. And so this is the anecdote. So Ginsburg, at the time that she was nominated for the court, somebody tells her that one of her law school classmates told his Rotary Club that she was known in law school as bitch. And she looks up when they tell her this and she says, better bitch than mouse. And, and it's such a perfect story. So my boss, Beth Donovan, said, well, why don't you ask Mark Memmott, who's our sort of ethics, style, everything czar, why don't you ask him if he has any suggestions about how to tell this story? So I wrote him, and he said, we're not bleeping it. The story's too good.
Well, but Mississippi Goddamn couldn't play.
Yeah.
So that's it. Anyway, so let's get a couple last questions, and then we want to hear about the violin. One of our guests here, or we're their guests, I guess, asks, what were your initial impressions of Justice Souter when he was first nominated? And how would he fare if nominated today?
Well, you know that the cry of the right is no more suitors. So they felt betrayed because he was not conservative enough. And I think, I think he views himself as quite conservative. And everything is relative, so that when Justice Stevens was named to the court, he was considered a moderate conservative. When I first started covering the court, Justice Harlan was considered a conservative. Ultimately, Justice Stevens was considered the most liberal member of the court, not because he had changed his views dramatically on anything, but because the court had moved so considerably to the right because of nominations from Republican presidents. It was so much more conservative than it had ever been before that what had been sort of center-right was now far left. And I think, and I don't think that hardcore conservatives would disagree with that. They want people like them appointed to the court. Hardcore liberals want people like them appointed to the court. Now, the question, of course, was about Justice Souter, who, in my view, is just a dear. So I'm not going to say anything mean about him because I thought he was a wonderful Supreme Court justice. God knows he surprised me from time to time. But he was always so fair and so thoughtful. And that's really all you can ask of a Supreme Court justice, is that he or she be fair and thoughtful.
To the violin, they found your father's Stradivarius. You tell me that they told you in New York when the press conference was held, it was one of the biggest there.
It was the biggest press conference they had had in memory anyway, including when they indict mobsters and high-profile Wall Streeters and things like that. And I think it's just because it was a good news story. And it was an ultimately good news story. We all would have loved it if my father had been able to know that it was there again. But
Remind people, an FBI call.
So, for those of you who didn't hear my story, I urge you to go online and hear it. Well, the reason to do that is not only is there a beautiful digital build-out with some wonderful pictures of my father, who I remember quite late in his life played the Beethoven Violin Concerto with the New Hampshire Symphony Orchestra here in Concord and in Portsmouth and one other place, I think. He played it 3 nights running, and he was in his late 80s at the time, which was, I remember reading I think a review in the Boston Globe saying it was just a stupefying feat to hear him still playing like that. But most of his CDs are on the Stradivarius, which he had for 38 years. He bought it in 1943, and it was, as he put it, his musical dancing partner for all that time. So he was 69 when it was stolen after a concert, and most of his recordings are playing the Strad, so I was able to use little pieces of those recordings in my story. So I think that gives it a whole different life than all of the very good print stories and even television stories that I saw. So if you Google something like recovered violin NPR, you'll get it.
But briefly, how was it found?
So what happened was, on the last day of the Supreme Court term, FBI agent Christopher McKeough called me, blessedly at home because I wasn't there to get the call, and my husband came in, played the machine, and called me up. He knew enough to wait until after deadline so that I wouldn't kill him. And when we were dating, he learned quickly that he would say, "You busy?" And I'd say, "Yeah, I'm crashing, bye." So he called me up and he said, "You know, the FBI called the house and is looking for you." I said, "Oh, there's probably somebody. He just needs a security clearance," and put me down as a reference. And he said, "Well, they left a lot of telephone numbers, and I called one of them, and it's the antiquities section." And I thought, oh, it can't be. It just can't be after all this time. And so I called back, and Agent McKeough wasn't there. He'd already gone for the day. So I called back at 8:30 in the morning, and he called me right back about 10 minutes later or 15 minutes later. And he said, "Ms. Totenberg, this is Agent McKeough, and I'm calling because we think we've recovered your father's violin." And I said, it was like just getting gobsmacked. We talked for a long time, and I said, well, he didn't want me to tell anybody because they were still trying to ascertain who was involved in this crime and how many people were involved in it. And I had all kinds of fancy ideas, that it was somebody who'd been involved in other art thefts, and said, well, if you'll give me consideration, I'll tell you where the Totenberg Strad is, and it was none of that. So, but he didn't know very much about the actual theft, so I filled him in on what had happened, and I told him that my father had a pretty good idea who he thought had taken it. He didn't know the guy, but he was a young musician who'd been seen loitering around the dressing room, and whose girlfriend had come to my father afterwards and said, or ex-girlfriend, and said, this is the way my father put it. God knows if she actually said that. She told me that he was a person of bad character. They told the FBI this, and they didn't try to get a warrant. And it's not entirely clear to me to this day why they didn't. I mean, maybe the law was sufficiently different at the time. Maybe they just thought it was a property crime and not worth the effort. I'm not sure, but they didn't get a warrant. And my mother, as I said in this piece that I wrote, famously went around Boston saying to her Flossie friends, does anybody know anybody in the mob? Because I want somebody to break into an apartment. So I told him all this, and he said, do you know the name of the person? And I said, no, but I can probably find out. And Chris McKeough became my new best friend for most of the summer. So I started with my father's friends who were still alive, the young people who are now in their 80s, and none of them remembered. My sisters didn't remember. And finally, we were talking about it. I was talking about it with my sister Amy, and she said, well, he had this secretary, Marnie, who he loved. He brought her with him from BU when he became director of the Lange School of Music. And he thought, and she was very young. She was in her 20s, early 20s or something, and he thought she was just a pistol. So I then set about trying to figure out, but she didn't remember her last name, so then I called the Lange School and I got somebody there and I said, I can't tell you why, but I need to find my father's secretary from 35 years ago. And her first name was Marnie, and it's really important. And I need to find out sooner, not later. And there must have been something about my voice or something that the guy called me back in 2 hours, and he said her maiden name was Marnie Duke, her married name is Marnie Mitzi, and she is the chief of staff for the president of Pepperdine. Wow. And so my father was right. She's a very capable woman, and I called her up, and she said, do you remember the name of the person who was suspected? She said, oh yeah, I remember him. And I saw him around the dressing room. And she said, I was there that night. I found the empty case in the basement, my father's violin case. And she said, I remember, his name was Johnson, Philip Johnson. So I called it back Agent McKeough, and I told him this story, and I gave him all of her information. And he said, well, that's who had the violin. And he had, this is an unkind thing to say, but I'm going to say it anyway. There is a God. He died at the age of 58 of cancer, and that was a year before my father died at the age of 101. And he had, I think that the rare violins people who are now restoring the fiddle believe that he couldn't have played it for more than a few years because he couldn't get it maintained. Because if any place he had taken it to be maintained, they would have recognized it. And so what happened was he left the violin to his ex-wife, and well, I have no idea whether she certainly says she didn't know it was stolen, and she didn't know him at the time it was stolen, and she may have had some idea that there was something funny about it because she didn't open the case for 3 years, and it had a combination lock on it. And 4 years after he died, 3 years, and so when she opened it, it says made by Antonio Stradivari in 1734 in the city of Cremona, Italy. And so she didn't know she knew enough he was a musician. He was a failed musician, but he was a musician. She didn't know she knew enough to know that there was a real possibility that it was a probability that it was a fake. There are hundreds of thousands, if not millions, of fake Stradivariuses around. There are some that are very good, and most of them just are $200 violins that are stamped out Stradivarius. So she got in touch with an appraiser on the East Coast, and he asked her to send pictures. And they were very good pictures that she took. And when he went in the meantime to look up what violins were made in 1734 by Stradivarius, and he sees that one of them was stolen 35 years ago. So he sees from the pictures that it's either a good fake or it's the real deal. And he goes to meet, they arrange to meet in New York, and he looks at the instrument very carefully, and then he says to her, well, I've got good news for you and bad news. The good news is it's a real Stradivarius. The bad news is it was stolen from Roman Totenberg 35 years ago, and I have to call the FBI right now. And 2 hours later, Agent McKeough and his partner were at the hotel with all the statistics. They just, in the days we live in the cab on the way over, they pulled it up on the web, and it has all of the measurements. It's a famous violin. It was called the Ames Stradivarius. And when they get there, there are 17 measurements or something like that to the millimeter, and the appraiser has a very special instrument to measure, and he would call out the measurement, and Agent McKeough was sitting there saying, yep, yep, yep. And so when he called me that morning, I said, well, I have to call my sisters. And he said, of course. And I said, I'll tell them not to get their hopes up too high. And he said, you don't have to worry about that. This is the violin. So, and then I said to him, does it have pearls in the pegs? Little tiny pearls in each peg, a pearl. And he looked and he said, sitting right here on my desk, he said, it does. I hadn't noticed that, but that is further confirmation. So it was an amazing thing. And I then, for all of you who are lawyers in the audience, I then was smart enough to get a lawyer. And to make sure that we could reimburse the insurance company, have clear title to it, deal with the U.S. Attorney's Office, and I will be forever indebted to Jamie Gorelick and Sharon Levin at the firm of Wilmer. I guess it's called Wilmer, Hale and Dorr now, which is partly a Boston firm, and they handled it all, and actually amazingly expeditiously, so that in a matter of it was really only something like 3 to 4 weeks from the time I actually ascertained who had stolen it, and that we had that all nailed down, that we took title to the violin, and they had this enormous press conference, and my brother-in-law sent me some clips, TV clips from around the world in which my voice is dubbed in all of them. So I'm speaking French, German, Japanese, Portuguese, and he wrote, I didn't know you spoke all those languages. So it was a huge deal. It was, it was on the front page of the New York Times and the front of the style section in the Washington Post, and it was just a huge story. I don't think I've gotten that much publicity since Anita Hill.
Well, just a question for you, because I know everybody, we have to wrap for some of the events.
This was good publicity. That was fun.
This is a great story. I just want to ask briefly, what are you going to do with it?
Well, my sisters and I are agreed that once it's restored, it's not playable right now. It's that we will sell it either to a performer or a trust that buys it for a performer, because it is not going to sit in somebody's collection. We want to go hear it, thrill audiences again all over the world, and it may take more time to do that. It may cost a little bit of money to do that, because maybe you can't get as good a price. I don't care. I want to hear Roman Totenberg's legacy. I want to hear the Ames Totenberg Stradivarius played before I die all over the world. So that's what we're going to do, and we will do it.
It'd be a little like hearing your dad. That's really quite something.
Well, I did feel all summer long as if he were just sitting behind me. I had the most, just those, I will end here. This is a good end. We went out after this incredible press conference where we were all doing separate interviews afterwards, and where at one point I called across the room to my sisters, I have to go file. I'll be back in 15 minutes. And we went out afterwards with my cousin, who my father brought from Poland in the late 50s. And she brought a bottle of vodka and shot glasses. And my father, every day of his life, I think adult life anyway, that we ever knew him, he had at least a shot of vodka. And if he went to play a concert before he left, just out the door. So we sat in a restaurant and we drank a shot of vodka to my wonderful father, and I really did feel that both he and my mother were with us on that day and a lot of other days this summer.
Isn't that a great story? It's such a great story. 888-805-6477. Look, on behalf of Constitutionally Speaking, for whom you are a pin-up, NHPR, which is just such a rock here in the Granite State, and Nina Totenberg, I think, the only person at NPR, such a luminary, that you have a pledge drive item named after you, the Nina Toten bag.
It's a beautiful bag. I really recommend that you buy it.
888. Thank you. Thank you so much, Nina Totenberg. Thank you.
Thank you all.